Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. We are now going to discuss a case law on forum shopping regarding arbitration. Right? So please remember, this is relating to the arbitration. Normally, in my CPC classes, I told you what is forum shopping and why forum shopping should not be encouraged. Simply to say, forum shopping is waiting for a bench. File it in the particular before the particular bench to get a favorable order because you are having some connection with the bench. Number one. Number two, some benches may be averse to you, in your view. Of course, justice, they will never think like that. But in our opinion, some judges, they are conviction minded, they are acquittal minded. Like that, we will have our own opinions. So in such a case, better to file it in another bench and bring it here, like that. So many tricks of the trade are there. They are called as forum shopping. In the case of grassing mills, I told you very in detail, right, how the parties will manipulate. That is not allowed in CPC, but that can be allowed in arbitration cases. This is what is stated by Honorable Justice Pratik Jain of Delhi High Court in the case of, please remember, Taqa India Power Ventures, Taqa, T-A-Q-A, India Power Ventures versus NCC Infrastructure Holdings, OMP EFA COMM of 2018, dated 9/11/2023. The main point is whether the judgment holder, please remember, or you can say enforce the proceeding, award holder, since we cannot say arbitration case judgment. So the award holder, please remember, whether he is entitled to proceed against the assets of the award debtor in any place. So normally the decree or the arbitration, they will clearly tell that you have to go and surrender the properties like that, you have to do like this. But when the matter is regarding the properties, so you can go to the particular place where the properties of the so-called award debtor are located, and you can select an arbitrator or you can go for the enforcement there also. This is what is stated in this particular case, right? So Taqa India Ventures versus NCC Construction. In this case, the main thing is enforcement proceedings were initiated against so-called appellant, that is Taqa India Ventures, on 24/1/2018. Right? So why? Because actually it is a case relating to the securities purchase agreement dated 19/9/2022 from NCC Constructions, OMA. So many things are there, but they failed. Securities they purchased, but they failed anyway. Enforcement proceedings were ordered by the so-called arbitrator. Now they have initiated the arbitration. Actually, the arbitration was conducted in the Singapore International Arbitration Center, Singapore. Now the point is whether the arbitration, the enforcement can be done in the particular place like that or not. So the debtor, now he has filed the appeal before the Honorable Delhi High Court. Please remember, first of all, he has, normally you may be knowing, according to section 14 and 15, I can say 14 and 13 of the CPC, the foreign award, if it is genuine, it can be accepted. The arbitral award, yes, is equal to, in CPC you can take it as arbitral award, you can get it enforced. Now when you want to enforce in India, the award debtor, he has contended that, please remember, basically he challenged the jurisdiction of Delhi High Court because the company, it is not located in India. It is not possessing any assets in India. So please remember, the jurisdiction was based solely on the security purchase agreement which was done in New Delhi. So where the cause of action took place. This is more important. Yes, they can do it The CPC will allow everywhere, they can't raise objection, but they stated that since they are located in foreign country, the award can be executed, enforced there only. And please remember, the debt of Himalayan Green Energy Private Limited has been written off. And please remember, it is considered as an asset by our award debtor. The award debt holder says that green energy, you have got some properties, but previously the court held that, or the award debtor claimed that the debt owned by the Himalayan people, it was written off, but the party, the award holder, he submitted that. The award claimed that, please remember, the award countered that the HG, Hindu Himalayan Green Energy, had not been written off, but it was only doubtful. It was written as doubtful, not written off. But they have got properties here and they have been running. The financial status is running to exist and the debt remains recoverable. So therefore, definitely they can file the enforcement proceedings in India also. So they claimed that this is nothing but forum shopping, but court did not agree. Enforcement of arbitration award, yes, it can be done any place because the properties are here. Yes, they can come and get them enforced. So very typical case of forum shopping. Please read it and enrich your legal knowledge. With this, I am concluding. Thank you very much.